And hello, and welcome to part two of reading the receipts, the mostly weekly update of the Blake Lively versus Wayfarer court case, providing deeply uneducated analysis of all the court filings hitting the docket. So glad to have you with me tonight for part two. I appreciate you letting me play catch up a little bit this week. So let's get started with our usual legal disclaimer. We're going to look at some legal documents, but I am not a lawyer. I'm certainly not your lawyer, and none of this is legal advice. All of the allegations that we're about to cover are just that. They're allegations, and nothing has been proven in court. Nothing we're going to talk about should be taken as a point of fact. This is all just opinion provided for entertainment purposes. All right, with that said, welcome. Like I said, part two. We just covered part one, kind of catching up with the docket and talking about all of the various motions to compel and the judge's decision on those. And so now I want to talk about Jed Wallace. Jed Wallace in particular, and also the tag employees. And the good news is I am hoping to get you out of here in under 2 hours. We shall see how we do, but this should be a relatively short one tonight. Good to see you, Obi-Wan Kenobi. Sorry you couldn't make part one, but I am glad to have you here. Caspian, welcome back. Good to see you in chat. Gina Richardson, appreciate your support. Thank you so much for being here. Let's go. Let's get going. All right. So the first thing we're going to cover is Blake Lively offered her response to the motion to dismiss in Jed Wallace's case over in Texas, in Austin, just, a few hours down the road. She came back with her support for it, which will finish out the pleading for the motion to dismiss. Now, as you saw, we've seen the motion to dismiss happen in the Wayfarer case, and I believe that Lively's lawyers here are really happy about that because they mentioned the motion to dismiss and that complaint being dismissed so many times in this complaint. So we start off with Lively saying, she's filing this motion in support of her motion to dismiss. Neither plaintiff's amendment nor their opposition can save their defamation case against Lively. Despite rewriting their initial complaint and redesigning their original claims, plaintiffs have still failed to demonstrate that Texas is the appropriate venue or jurisdiction for their claims. It is not. Or that their defamation claims can survive their failure to meet basic pleading requirements and the multiple applicable privileges that bar it. Welcome back in, Marcy Jinx and the Junk Farm. Glad to have you here for part two. So we're going to the first to file rule again, arguing that, plaintiffs have put directly at issue the truth of Lively's allegations, which are already subject to litigation in New York, which until June 9th, when the first file court dismissed their defamation claims, bolded with prejudice, the New York Wayfarer plaintiffs asserted a defamation claim that was based on the exact same legal theories as the plaintiffs here. Even if they could overcome the first to file rule, which they cannot, the plaintiffs grasp at straws to establish venue and jurisdiction. The events giving rise to the alleged defamation occurred outside of Texas, and Lively's prior Rule 202 petition, which was never even served, cannot support either venue or personal jurisdiction over her. If you'll remember, Wallace's argument was that because he's based in Texas, the jurisdiction should be Texas, and because Lively had filed a prior 202 motion for deposition, that was like a first file action and showed that she was accepting jurisdiction in Texas. She's saying, look, it was never even served. Like, I don't know if this motion can be the basis for your jurisdiction, but we never even managed to able to give you the document to give you to serve the Rule 202 deposition request. So, as for the merits, the amended complaint fails to state a claim as a matter of law, including because the statements at issue are protected by the same litigation and fair privilege reports that the first file court already found doomed the defamation claim of the New York Wayfarer plaintiffs. She then goes on to point out in the footnote that the court dismissed the New York Wayfarer party's amended complaint in its entirety. There is the sound of trumpets and party poppers going off in the background as this is being written. I can hear them. Subtle Murder, good to see you. Only 3 minutes late. You're good. You're good. Marcy Jinx says they were popping bottles for sure. Yeah, I mean, you can read it dripping through this of how much they are enjoying writing that. The first to file rule requires dismissal of this lawsuit for all the reasons articulated in the motion, and especially in light of the first filed court's recent dismissal of all claims asserted by the New York Wayfarer parties in the New York litigation. Has it been dismissed? Was it dismissed in New York? I missed that. Did anybody catch? Was it dismissed in New York? The first filed court dismissed the defamation claim against Lively with prejudice under California law, holding that the statements in the CRD complaint alleging harassment and retaliation are protected by the litigation privilege, and the act of providing the CRD complaint to the Times is protected by the fair report privilege. She includes it and attaches Judge Lyman's decision and order as part of her exhibits. As explained in the motion, those now dismissed claims were nearly identical to the ones the plaintiff first asserted in the California complaint and then retooled for his lawsuit to avoid the jurisdiction of the first filed court. A comparison of the defamation claims plaintiffs assert in this litigation and the dismissed claims in the New York litigation demonstrates the substantial overlap between them. I've lost. I feel like I do not encourage irresponsible drinking, but I feel like you should take, a sip of your drink every time the word dismissed comes up tonight. It's a lot. Caspian says you have to find joy in the little things and absolutely deserved smugness in the big things. Oh, absolutely. I mean, I don't think anybody was expecting it to get dismissed entirely with prejudice for most, all but two of the claims. So, I would put it this way. If it was the other way around and Lively's suit had been dismissed with prejudice, the gloating would be far greater, right? So I don't mind Lively's lawyers taking a moment to celebrate. Dismiss. Yeah, the dismiss. It's like that Eminem video where they just do Mom Spaghetti over and over and over again for all of the lyrics, only it's just dismissed for all of the lyrics. Anyway, she makes the point that basically, not only is Jed Wallace's claims very similar, but it looks like they lifted a lot of the same text, talking here about in the Wallace's claim here that plaintiffs sexually harassed Lively and retaliated against her in a violation of state and federal laws. They quoted the same thing here in the Wayfarer party's defamation claims: engaged in, permitted, or failed to prevent sexually inappropriate conduct towards Lively and others, and the Wayfarer parties retaliated against Lively and others for reporting the alleged sexual misconduct, including by propagating false and misleading narratives about Lively for the purpose of damaging her image and reputation. She compares the second complaint here about Miss Lively and her agents leaked the CRD complaint to the press and other third parties, including the New York Times. Miss Lively or her agents leaked the CRD complaint to the public, including the New York Times. That essentially there is significant overlap between these claims because they're virtually identical. They almost look copy and pasted. The first to file rule requires the court defer to and avoid interference with the first filed court, which has already adjudicated virtually identical allegations to those in those lawsuits. She also makes this point here in the footnote, which I had to go Google because we're getting some legal language here. Lively respectfully reserves all rights to seek appropriate relief, including dismissal, on the basis of res judicata or collateral estoppel. I don't know if I'm saying that right. Res judicata. Essentially the idea that you cannot face the same charges twice, right? This double jeopardy rule, this idea that, you go to court for a certain thing and you get a judgment on that thing, you can't constantly be hauled into court for the same thing. The court's already decided. So she's making the argument here that not only is Jed Wallace's claims very much the same, she's arguing they are the same, and that the decision in the Southern District of New York court basically means that she shouldn't have to face those same allegations in Texas and have to fight them here as well, and that's a valid reason for dismissal. I haven't seen that come up before, and obviously because it hadn't been dismissed, I would have thought they would have kind of just pushed this in, to say, hey, if it is dismissed or it is part of this. But yeah, now that it's been dismissed, it's a good argument. I don't necessarily know that you could face it in the same, cross states because of it. She goes on to say the opposition ignores and therefore concedes that the New York litigation's now dismissed defamation claim is virtually identical to not only the defamation claim asserted here, but also that previously asserted in the California complaint. This is the original one that they filed against the New York Times that they dropped to then consolidate with the rest of the claims that Jed Wallace was originally part of. Plaintiffs mount a single argument with respect to the obvious overlap against these claims against Miss Lively, that the New York litigation plaintiff's lawsuit was about what Miss Lively purportedly did to 6 of them and not to the plaintiffs, by virtue of them not choosing to be plaintiffs in the New York litigation. She's saying the only difference was that he didn't choose to participate in the New York litigation. So, but otherwise the claims are the same. Gina says, I can say that she actually has really good lawyers. There's been a lot. I think a lot of this stuff has mostly been signed off by Ezra Hudson. I don't remember if this has as well, but it's been really good to read a lot of the stuff from Lively. I prefer to read this stuff than the bombastic stuff that comes out of Liner. What's all this about dismissed claims, says Marcy Jinks. Somebody should have told us. Somebody should have mentioned that the claims were dismissed in New York. I missed it. I missed it. Sotomayor says, I think I missed it. Were the claims dismissed? I don't know. Let's read on. I'm very sure that even having already said it so many times, I'm very sure we're almost at another mention. But the first of all rule does not require complete identity of parties, just that there's substantial overlap. And then separately from the New York Wayfarer plaintiffs' now dismissed claims, the first to file rule also requires dismissal because the New York litigation against the plaintiffs and the other New York Wayfarer defenders is proceeding apace, including on Lively's claims that plaintiffs engaged in a retaliatory campaign against her. Someone says, I would have had no idea. I know. It's a good job they mentioned it. Obi-Wan Kenobi says, Lively actually has real lawyers. I mean, they're all real lawyers, right? They've all passed the bar. I definitely think there is a level of professionalism that is more weighted on one side. Plaintiff's role in that campaign is at a central issue in both the CRD complaint and the New York litigation. Ignoring that fact, plaintiffs incorrectly claim that this case is about the false accusation they were involved in the predatory conduct on the set of the film. Plaintiff's argument overlooks their own pleading, which alleges that the CRD complaint contains defamatory accusations that plaintiffs engaged in a retaliation campaign, the exact conduct at issue in the New York litigation. I'm not where I was meant to be. So yeah, the plaintiffs repeatedly poured out that Lively added the plaintiffs to the New York litigation, but they do not argue that the timing makes this first file case, nor can they, because the rule that does not require identity of parties. She's saying that, look, it doesn't matter. The lawsuits are so substantial in their overlap. Plaintiffs ignore the only reason they filed this lawsuit because they knew that Lively was planning to imminently add them as parties in the New York litigation, which, if you remember, Wallace's original court complaint was wanting a preliminary judgment because he knew that he was going to be sued, and so he filed this so that he could get a judgment before Lively sued him. So I mean, he's accepting there that that was incoming, and that was first filed. The veracity of the statements about plaintiffs' participation in the retaliatory scheme is the core issue in both cases, and the proof would be the same. Therefore, there is unquestionable overlap between the two cases. Hard to disagree with this. I mean, the issue in both of them is whether Jed Wallace participated in a smear campaign against Blake Lively. If he did, then it's not defamation to say that he did. If he didn't, then it would be defamatory to claim that he did when he didn't. That would not, even if the CRD complaint accused the plaintiffs of sexually harassing Lively, which it plainly does not, that would not change the fact that the core issues, proof, and questions about the on-set harassment are a central subject in the New York litigation and currently the subject of active litigation. Didn't mean to click the footnote. Lost now. There we go. First to file rule necessitates the dismissal of this case because its subject matter entirely overlaps with the New York litigation. Again, hard to see how this was fought. I didn't really feel like there was a good argument for it. Further, the opposition does not even attempt to address plaintiff's admission in the original complaint that they filed this case in Texas because they were threatened with liability and hoped for an early adjudication without waiting until Lively should see fit to begin action against them, right? This is what I just talked about. He filed that originally because he was anticipating a suit against them, so he filed first. Such a race to the courthouse shortly after dodging service for the pre-suit discovery should not be rewarded. Settlement says, I always thought it was strange Jed Wallace focused so much on the sexual harassment allegations of the original complaint when it's obvious they weren't about him. Yeah, I mean, that's where he's trying to say that it was defamation, right? Like, because that's the strongest case, right? Arguing, as Lively is going to talk about here, that he engaged in digital manipulation and sentiment analysis, sentiment manipulation is aligned with what he claims he does anyway, so it's not really defamation. We talked in part one as well about how Friedman's own motion to compel against his law firm also brought up the fact that, like, hey, whether we talked to content creators has no bearing on Lively's sexual harassment claims. And it's like, yes, but she's also claiming a retaliatory smear campaign, and that would be very relevant. Both sides seem to be kind of pushing this idea that, oh, the only thing that matter is the sexual harassment claims. And it's like, no, this is mostly about retaliation. Lively's main claims are employment law, are about failure to investigate sexual harassment and retaliation for sexual harassment. They're not really about the sexual harassment itself. They're really about the employment law surrounding it. So I don't know why they feel like focusing on it, but it might be just that this is as strong as their argument gets, and so it's the only Hail Mary they've got. She talks about, the venue is improper. Trying to find where I'm looking for. Now I'm lost because I'm looking at the wrong pages. But now abandoned belief. Where did I lose that? I apologize. Chat, bear with me 1 second. Was it all the way up on page 7 that I did this? Page 7. Da, 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 da. I don't know where the piece that I wanted to talk about was. Oh well. Oh, it was here. It was right here on the page I was on. Anyway, so yeah, she goes on to say, look, about the venue arguments. This is a little more rough for me because, again, we're starting to get into, the fact that plaintiffs accused Lively providing the CRD complaint to the New York Times, not to any Texas-based outlets, alleged the CRD complaint was republished around the world. And in a smart move, they kind of go, hey, his lawyers, in a separate case, the plaintiff's law firm successfully argued in a motion to dismiss for improper venue. The type of allegations plaintiffs make here are insufficient as a matter of law to establish venue. Talking about the fact that, CNN publishing something defamatory in a defamatory statement doesn't mean that, the venue would be Texas. In fact, the only alleged connection between CNN and this district is the CNN's reports were broadcast and published through Texas, which is what Wallace is alleging, whereas his law firm in this lawsuit were arguing essentially what Lively's arguing now, that, like, it was only just published through Texas. It doesn't target Texas, and so the jurisdiction doesn't count. So it's kind of funny that they brought up that, like, hey, they're arguing the other side here. But what I want to call out is here is plaintiffs in their opposition have abandoned the information and belief statements as part of their affirmative case and do not claim them as a base for venue. Part of his amended complaint was this idea that when Lively went to South by Southwest, she ignored a protester holding a sign saying Blake lied, and that was defamation. That she went to a hotel and her failing to engage with somebody else was also defamation. Lively points out that they have completely abandoned those claims as part of their establishment of venue. Next one's a water, says Caspi. Thank you, Mossy Jinx, for helping me on what page I was on. Protester, yes, no, that's what we're going to call them. They were a protester. They are a protester. Plaintiffs' myopic focus on their presence in Texas ignores that Street only became a resident of Texas after filing the lawsuit and was incorporated in California when Lively filed the CRD complaint for the last 16 years. Also fails to address that Wallace himself admitted that he was doing business and providing services to individuals in California and said that he considered the impact of his work to be in California. Wallace also, remember, as part of the subpoena, said that he travels a lot and is rarely home. So that alone, right? Like, just by saying that, I live in Texas, well, you're rarely there, my friend, even by your own admission. And this is the thing that I talked about before, was this 202 petition as well. they try to claim that that's the basis for venue. Lively brings up that the substantial events at issue in the Rule 202 petition, Wallace's conduct in the retaliatory campaign, are in opposite to the substantial activities from which the plaintiff's claim arise from the CRD complaint. So Lively saying, look, even if, right, me filing that deposition, your conduct in the retaliation campaign, I'm looking for that, and that might be based in Texas. What you're trying to claim defamation on, the CRD complaint, definitely wasn't part of Texas. So therefore, it's another reason why you shouldn't be granted jurisdiction here in Texas. In the venue in this district may have been proper in the Rule 202 petition because Lively's inquiry arose out of Wallace's in-state conduct does not make it a proper claim arising out of Lively's out-of-state conduct. Essentially saying that just because Lively was trying to pursue him in Texas for the retaliation campaign doesn't mean that Wallace gets to claim it is the proper basis for him claiming the defamation, which arose outside of Texas, should also be based in Texas. Sure. Like this time it starts to be like lawyer stuff. Talking about the Rule 202 stuff. You know, just because she argued that they're arguing that because she sought pre-suit discovery, they failed to address that the filing of that petition and the non-suit 14 days later without ever serving Wallace does not constitute litigating extensively on the merits, which is what I said in her opposition. In his response was, I don't believe that a Rule 202 pre-suit deposition would count as like a substantive act in Texas or bind her to Texas jurisdiction. That's what she's saying. Plaintiffs attempt to argue that the Rule 202 petition is akin to an original action because it sounds in equity, but offer no authority for that proposition. They failed to address that even if the 202 petition did constitute an extensively litigated original action, it would still be insufficient to establish specific jurisdiction because this lawsuit does not arise out of the petition. Right? That was him filing it of his own accord. It didn't become as a result of it. So therefore, plaintiffs cite no authority supporting the notion that an unserved Rule 202 petition confers jurisdiction over Lively in a separately initiated lawsuit. They're not part of the same case. Therefore, it does not count. Where are we going now? We're on page 12. Plaintiffs assert no facts showing that Texas is the focal point of the CRD complaint. Lively published the CRD complaint in Texas, or that Lively relied on Texas sources to the contrary. Plaintiffs admit that the CRD complaint was published around the world, and with respect to Wallace's work mentioned in the CRD complaint, he was doing businesses and servicing individuals in California. Plaintiffs rely on the fleeting done material reference in the CRD complaint that Wallace is based in Austin. But that is not a collateral reference to Texas, does not confer, but such a collateral reference does not confer personal jurisdiction. Just because we mentioned that you are based in Texas in the CRD complaint doesn't mean you are covered by Texas jurisdiction. Pointing out again, not tied to Texas, Street was a California corporation until about 5 minutes ago when you saw an incoming lawsuit and decided to quickly file paperwork. And the important point about that, and I didn't bring that up, and I should probably bring that up given the guest of what we are going to talk about tonight and for the rest of it, is where is the actual exhibits? Oh God, I'm gonna have to click exhibit list and go find which of these exhibits it is. I think it's this one, Exhibit D, the incorporation of Street when it was back in California, right? No, not this one. Maybe E? Maybe it's the transfer then. I believe so. But wasn't it the case that the address here and the service of process was Brian Friedman's law firm address? It's another connection from Jed Wallace to Brian Friedman. I should have probably mentioned this in part one when we were talking about why Lively is serving Brian Friedman's law firm, because up until he did move his company from California to Texas, his agent for service of process was Brian Friedman's law firm. So Jed Wallace has been connected to them and only moved to Texas when he knew that he was going to be added to the New York law firm. So yeah. Obi-Wan Kenobi says, when people talk about not liking lawyers, this is what they mean. The lawyers like Friedman. Yes. No, I have gained a great deal of like insight and appreciation for lawyers because my understanding of lawyers were, the sharks and the frauds, the Freemans of this world, not so much the other people that I have come to interact with and learn about through the course of this case, who are incredibly smart people. So I was very moved by it. And I also thought lawyers were a lot more contentious than they were. And I've learned that a lot of times, because they're often working together, even when they are going back and forth, there's still like a professional courtesy in the way that they treat each other and deal with each other, because they know they're going to have to work with them again at some point. So they want to build those relationships and be friendly. So that was kind of news to me. All right, plaintiffs appear to retreat from their theory that information belief statements confer jurisdiction by referencing the argument only in a footnote. So we talked about that. They don't, talk about those anymore. Even if plaintiffs were to surpass those fatal hurdles, the information's belief statements would not support subjecting Lively to personal jurisdiction because they occurred in Texas after the plaintiffs filed this suit. And I didn't see this brought up. I'd missed it as well. But the whole point of he brought the lawsuit, but then the South by Southwest premiere of Another Simple Favor and also the interaction at the hotel all happened after he had filed the lawsuit. So he's trying to use those as his basis for, this is why I filed in Texas and while Texas jurisdiction counts, but they happened after you filed. I was like, oh yeah. Marcy Jinx says the Reb Maisels. Yes, Reb Maisel is fantastic. And that winged eyeliner is always on point. I'm very impressed at how good that always looks. As somebody who spent a good deal of my 20s doing eyeliner at the goth club, I'm very impressed with a good, solid, unblurred winged eyeliner. I'm very easily impressed, is what I'm saying. Where are we? So let's go answer the actual statements for claims for defamation. Plaintiffs confirm that the complaint are two publications, right? The CRD complaint and the draft complaint. Can't remember what they call it, not the prototype, there's something else. They call it the proto something, I can't remember. Which were filed and published to the media, right? Plaintiffs gloss over the fact that Miss Lively's argument that the FAC does not comply with Rule 8. They include a single footnote on the topic claiming the case cited in the motion is inapplicable and the FAC complies with it because it specifically alleges that Lively provided all of this information to the report and the newspaper, ignoring that their own pleading defines Lively to include any number of unspecified people, including anyone at our corporate entities that she or her husband owns, or fails to include any allegations with respect to any specific statements published or demonstrated agency. So somebody, we don't know who, said something is essentially what Lively's arguing here. He hasn't kind of given any specificity to what the defamatory statements are. As far as their attempt to distinguish, oh, never mind, we're not doing law. Plaintiffs failed to address falsity in detail. Without supporting facts, plaintiffs conclude the FAC alleges that these statements were and are false. Yep, we called that. Plaintiffs failed to confront Lively's argument the FAC fails to state a claim for defamation by implication because the inference on which it's based, the reader would view the caption of the CRD and attached complaint and infer that plaintiffs engaged in sexual harassment is unreasonable. Yeah, I'll come back to that. I think this is agreed. That's just because there's this list of people here and a list of claims, you don't necessarily know which one's lined up with which. So why would you just immediately assume this? This is just normal. This is normal for a legal complaint. I don't get why he's making that argument. Agreed. Oh, and now I've got to go back to what page I was on, which I think, spoilers, not quite. There we go. Come back to that. Plaintiff's response to the argument the alleged defamatory content is not more damaging than the admitted truth misses the point. Plaintiffs assert that it would be detrimental to name to their name to falsely accuse them of weaponizing a digital army in retaliation for reporting sexual harassment. But the admitted truth is that Lively did report sexual harassment to Wayfarer, which prompted TAG to approach the plaintiffs about engaging in a social digital manipulation and remediation campaign on behalf of Wayfarer, which then prompted the plaintiffs to, in fact, perform a job for Wayfarer, TAG and Baldoni. In other words, the plaintiffs admit the Wayfarer hired them to engage in public relations mitigation and remediation in direct response to Lively's reports of sexual harassment. They argue there's no difference between that truth and the alleged defamation. Essentially, the only difference is the wording of the phrase digital army that he appears to be upset about. Plaintiffs further failed to overcome that the FAC does not plead any facts demonstrating that Lively should have known that the plaintiffs didn't assist the Wayfarer parties, TAG, Nathan, and Neville in their retaliatory efforts to bury her. So again, we've talked a lot about this with defamation. How would she have known that this was a false statement that she was making? In fact, from all of the text messages we've seen and we're going to see through the rest of tonight, it would be the other way. It seems very likely he did engage in this stuff. The First File Court recently considered a similar allegation in the New York litigation, holding that there is no basis to infer anything other than that Lively filed her complaint in the case based on the CRD complaint in good faith. Again, relying on Lyman's opinion, where he had pointed out that, yes, she seemed to very really believe the allegation she was making and file her sexual harassment complaint in good faith. Again, the only fact to which the plaintiffs point to with respect to fault is the Rule 202 petition, saying that, oh, well, Lively didn't have enough facts, and that's why she's deposing me to come after it. But again, how can the act of filing that after the CRD complaint possibly demonstrate the state of mind at the time of publication? The same unrebutted reasons explained in the motion, the Rule 202 petition does not support a finding of negligence, which agreed. Settlement says we didn't bury her, we just smeared her, just like on toast. Mossy Jig says it wasn't a literal army, Judge. Yes, we're more considered a volunteer collective. I run a digital volunteer collective. I don't believe in armies. We are a group of conscientious social digital objectors. I don't know where he's going with it, but again, we'll talk about that more later because that is coming up in his emails and stuff that he's got coming up. So they argue that defamation per se hinges on arguing that Lively accused him of sexual harassment. But again, CRD complains for itself and does not include any accusation that he did engage in sexual harassment. Plaintiffs claim that accusing him of weaponizing a digital army harms him in his professional is not credible, since he has built a book of clients by doing just that to help clients mitigate crisis. And she points to his original complaint where he talks about exactly that. He owns a crisis mitigation firm, primarily helping families and individuals who find themselves unjustly attacked, extorted, doxxed, swatted, scammed, or needing help navigating their most frightening situations. Doing so requires a low profile, so that when people retain Wallace and Street, they do not call attention to themselves. And then he goes on to say that he was there approached by TAG PR to assist it in social digital mitigation and remediation regarding Wayfarer Studios. So saying that he weaponized the digital army would not harm him because it's essentially what he's claiming to do. Indeed, plaintiffs' ability to weaponize a digital army and launch the type of social media campaign they did with respect to Lively could be good for plaintiffs' business. Wallace admits that the real harm to his profession is not what Lively said, which he must prove to state a claim for defamation per se, but rather that his work for the Wayfarer parties has lost its cloak of anonymity. Pointing back to what he just said there of, part of the damage here is that he should be allowed to do this anonymously, not that it's particularly damaging. And like Lively alleges, like if he could do the type of thing that he's being alleged to do, that would actually be really good for his social media mitigation business, right? Like, this is what I can do. This is the type of thing I can do. Oh, I thought I was signing up for the digital navy, says subtle murder. Oh my god. Good job, chat. Keeping me entertained. They also argue, plaintiffs argue that Texas law should apply, but fail to provide any argument or basis for why that should be the case. For the reasons explained in the motion, California law should be applied. The first file court made such a determination in the New York litigation when it determined that the statements in the CRD complaint and the alleged leak of the CRD complaint were privileged. I don't know what happened to those complaints, though. Does anybody know? Does anybody know what happened to those in the New York litigation when it determined them? I don't know. They're dismissed? I think they might have been. It's interesting how they've stopped saying dismissed all the time now. The court should do the same here, considering the plaintiffs do not even attempt to mount a serious argument for the application of Texas law. Under California law, the litigation, fair report, and sexual harassment privileges, which appear on the face of the FAC, bar plaintiffs' defamation. They concede that the litigation privilege protects them, which is consistent with the first court's file holding. I don't know which is there. Instead, plaintiffs argue the litigation privilege under California law does not protect press releases. Oh, so yes, this is argument by silence, I guess, right? Because they argued, well, Lively's saying that it's protected under California law as under litigation privilege, but it doesn't protect press releases. And so she's turning around and saying, okay, so you do accept that it would be protected under litigation privilege, but you're arguing that it's a press release. But as seems a fairly obvious conclusion here, neither the CRD form nor the attached CRD complaint are press releases, or that Lively or agents issued a press release that includes defamatory statements. Thus, the California cases cited by the plaintiffs, none of which concern communications made in a judicial or quasi-judicial proceeding, does not apply. Moreover, that Lively or her agents may have leaked the CRD complaint to the public has no bearing on the applicability of the litigation privilege. Just the Caspian says I'm solidly halfway through my three quarters of a liter electrolyte because of drink dismissed when said. I do not recommend trying this with alcohol. Absolutely agreed. Fun drinking game though. Fun drinking game. All right. I think this was it. We got I think we can't us. Plaintiffs merely conclude without support that in any event Texas law should apply, which is a fantastic legal argument. Just should apply. Yeah. She calls that out of like, hey, he just kind of tries to sneak that in. Where am I trying to find? Last piece. Plaintiffs argued that the sexual harassment privilege does not apply because Wallace has alleged actual malice, and that one statement, the plaintiffs weaponized the digital army around the country from New York to Los Angeles, is not covered by that privilege. Plaintiff ignores that the sexual harassment privilege projects statements not just about harassment and retaliation, but also aiding and abetting the same, including executing a social combat plan. Therefore, plaintiffs, plaintiffs do not adequately allege that Miss Lively made the statements, even with negligence, let alone malice. So, pointing out again, she believed everything she's saying. Moreover, the broad immunity provided by the sexual harassment privilege covers that one statement because it's related to an incident of sexual assault, harassment, or discrimination. And so, arguing that it should be dismissed. I think it's a fairly strong. I don't know if it's just because of all the whooping and hollering at the beginning about how the New York one was dismissed. But I do think like the arguments of it's already active in New York, it's essentially the same case in New York, it's arguing the same statements of fact in New York, it's pretty damaging. I think it is pretty compelling that this gets moved to New York if it doesn't get dismissed. All right, that then brings us to back to New York. Wallace tried to file for a stay of discovery over in New York. It was dissed by a miss, says McKenna-Hobie. Wallace came over and said, look, I'm asking for a stay of discovery because I have a pending motion to dismiss over in Texas. And I have a pending motion to dismiss here in New York, and it's going to get moved to Texas. So I should be stayed from the motion. He argues that essentially discovery has proceeded by and against the Wayfarer parties, who Lively continues to define as including Wallace and Street, who are an individual and a small company from rural Texas. This has caused the Wallace defendants to participate in discovery that in large part has nothing to do with them. He's just a bystander, everybody. He has nothing to do with any of this. but continues to require their substantial attention. On Friday, my client, which were asked to consent to a deposition protocol for 40 depositions, would amount to almost 280 hours of deposition, far from their home in Texas. And it should be noted that the Wallace defendants have no affirmative claims pending in the consolidated cases, so they're just defendants. They argue for a motion to dismissal based on jurisdiction, venue, and the merits. They say that jurisdiction doesn't count because this court doesn't have personal jurisdiction over Wallace and Street, which has been fully briefed. Wallace submitted a declaration that he is not domiciled and Street is not incorporated in New York, so there is no general jurisdiction, and further lays out how neither Wallace nor Street have any contact to New York. He argues for venue, that Lively bears the burden of showing that venue is proper for each claim against each defendant. Venue is a substantial argument for Wallace and Street, and about the merits. Wallace and Street were advised Friday that Lively's dropping her IED claim, leaving only 2 claims against Wallace: false light invasion of privacy, which is not recognized in either New York or where Lively lives, or Texas, home of Wallace. And then for the second, aiding and abetting harassment and retaliation in violation of California law, Lively fails to plead that Wallace and Street were aware of the sexual harassment, or they knew of the astroturfing that Lively falsely alleges was in retaliation for the sexual harassment, a required element. The growing burden and breadth of discovery, including dozens of depositions, warrants a stay. And he talks about how he had told them that he was going to ask for a stay, and that in response, Lively rejected the request for a stay and served a stunning 98 document requests and 16 interrogatories. They are broad. In one, Lively requests all documents and communications concerning any Wayfarer defendant, but Lively includes the Wallace defendants in the definition of Wayfarer defendant, so any document and communication Wallace and Street might have got since July to now should be produced. This is as broad as discovery can get. That does seem a valid point, that if they are defining Wayfarer defendant to include Street, then any documents or communications concerning Street or Wallace would be everything he's ever produced. So yes, I do think that that is incredibly broad and probably needed to be narrowed. So yes, so he goes on to say that, you know, he's producing all of this stuff and we want a stay of discovery. Lively's counsel informed Wallace and Street that Lively's opposed and served well over 100 requests. Lively came back with her response and just basically says, look, he shouldn't be granted a stay because this is active in Texas, and whether he's doing discovery here or in Texas, it's largely the same. It's largely the same claims. It's largely the same issues. It's going to be the same discovery. Even if he gets dismissed here, he's suing me over in Texas. So like, it's all the same thing, right? Arguing that his motion to dismiss shouldn't be the grounds for a stay. Remember, Sloan wasn't granted one based off her pending motion to dismiss either. And so, you know, Wallace Adorno brought up his declaration. And Lively pointed out, and I think we've made this argument a bunch of times, a defendant cannot defeat personal jurisdiction merely by asserting that they were not involved in a conspiracy. Mr. Wallace's self-serving declaration does not warrant a stay or a dismissal. So simply filing a declaration that I didn't do it shouldn't be enough. So yeah, she submitted some evidence as well as part of this, and we'll get to that in a second. But do I have his declaration? I do, but I don't think I'm getting to his declaration right now. Okay. So in response, the judge basically denied it. The judge agreed that basically he's going to have to do it either way. What he does say, however, is the Wallace defendant's motion to dismiss does present substantial arguments for dismissal, which, if you remember, was what he kind of said about the New York Times. So it could well be that Lyman dismisses Wallace from the New York complaint, which would not be great. Because I don't know what happens then as Lively is pursuing it in Texas and moving it back to New York and asking for a dismissal there, if she can then go after him, or what happens, or if he's just removed entirely. So interesting to see what happens there. However, a stay of discovery would only minimally ease the burden of discovery on Wallace, but would significantly prejudice Lively. Although the Wallace defendants suggest that they are burdened by participation in the extensive discovery that has little to do with them, they do not need to participate in such a discovery. The discovery that does concern the Wallace defenders is much lightly and will not lighter and will not be eliminated by decision on their favor on the motion to dismiss. They'll still need to produce all of this stuff, even if they're not a party to the actual case. And I talked about this, I think about 2 weeks ago, that I do think they may well get dismissed. I do think they could be, there's an argument for kicking them out because Lively's core complaint isn't really about the retaliation campaign. It's about the employment law and sexual harassment stuff. So I think, yeah, there's a valid argument that Wallace gets kicked out because she's not really going after him for this, the smear campaign. So I do think, yeah, that could happen. But anyway, he argued no stay, that he's still in it and still got to produce. So he's got to pull out his evidence. Now, as part of that, he did produce some evidence and Lively unsealed it, which is where we get some big stuff. So let's go to Jed Wallace's declaration. So this is the declaration that Jed Wallace signed where he said, under oath, I do all these things under danger of perjuring myself. My name is Jed Wallace. He is over 18 years. He lives in Texas, blah, blah, blah. I work with street. I have street, all this stuff. Okay. My earliest involvement in my limited role concerning Justin Baldoni or Wayfarer was August. I am the only employee of street that engaged in that limited role. All of the limited work was done by me from Texas. None of that work was in New York. None of that work was directed at New York. Neither I nor Street posted anything on social media on behalf of Wayfarer parties. Neither I nor Street have asked or directed anyone else to post, comment on, or like any social media posts. I have never published directly or indirectly any information or content regarding Lively. I've never met Lively. I do not have a digital army in Los Angeles, New York, or anywhere else. I do not have, work with, or direct a team in Hawaii, and I have never been to Hawaii. I have an understanding of what a social combat or social manipulation plan could be, but that is not a service I provided to It Ends With Us, Wayfarer, Baldoni, Blake Lively, Reynolds, or any of the Lively or Reynolds businesses or families. I do not specialize in executing confidential and untraceable campaigns across various social media platforms to shape public perception. In early August, I was contacted by Melissa Nathan about Justin Baldoni and potential stories of social media attacks on him. My job was to read, analyze, and assess all forms of media and trends taking place with respect to various issues. Because I provided feedback back to Nathan, who I understood to be in California most if not at the time, I only considered the impact of my work to be in California. The goal of my work was to inform her and her team who I anticipated would be in California, and I thought of her work as for Wayfarer Studios, which I knew and know to be based in California. In other words, I thought I was doing business, providing my services to individuals in California. So this is what he stated, based off, him what he's saying. Now, where this comes interesting is Lively attaches an email exchange. This comes from Street Relations. This is part of some of the work that they have already produced to Lively. So Jed Wallace and Street Relations turned over this email exchange to her. It is a continuation of pieces that we have already seen. So let's bring up Lively's amended complaint on page 73. You will remember, and I've shown this a bunch of times, right, when I did the very first episodes of reading the receipts and we talk about like way back, the smear campaign. They talked about we're going to enact the digital campaign, get the green light from Jamie, and then this email comes up where they're talking about, hey, thanks Katie, clarity, do we understand? Does this cover your initial fee plus what we discussed in terms of social media mitigation and proactive fan posting to counter the narrative? Or is this in addition to the $15K previously agreed upon fee for tag? I've talked about it a little, and he says in short, is the total fee incurred by Wayfarer $30K, or sorry, Jennifer Abel says. And I talked about it a couple of weeks ago, right? Let me see if I can bring up that graphic that I had. And I thought that this talked about 3 separate fees, right? Katie's fee, the fee for tag, and then the fee for this separate team based in Hawaii. I was wrong. That is not what this shows at all. What we're talking about here are 2 separate fees. Katie's fee is Katie Case, who works for Tag, which was the 15K that they had, or 15K that they had asked for originally. What they're asking for here is Jed's team. Is Jed's team including, like, is the amount that we're going to pay for Jed's team include the 15K we already pay for you, or is this in addition? In other words, is it just 30K that we're paying, or is it more? We know this because in this email exchange here, Melissa Nathan says, "Hi Jamie, please meet Jed, who will be having his team assist on all social media activity based off our conversations, as well as their digital plan that you are in receipt of," which I really hope they end up getting a copy of that. He is aware we're going to go for their quote 2 option for $30,000 per month for 3 months. And then it says, Jed and team has worked on some of the most, and then cuts off. Oh, so infuriating. I wish I knew what the rest of that said. Please tell me. Please tell me. So this, if you remember, is coming back to Melissa Nathan's text message about the 2 options. Now, I'd missed this, I guess, over the time of looking at this. But Nathan says, we took the day today to do some research and get digital quotes in from the 2 teams we use that get the best results. And there's 2 quotes. Quote 1 is $175,000 for a 3 to 4 month period, includes website, full Reddit, social media, social account takedowns, full social crisis team, blah, blah, blah. Quote 2 is $25K a month. This is from team 2. Minimum 3 months, needs the time to seed, the same as above. But this will be for the creation of social fan engagement to go back and forth with any negative accounts, helping to change the narrative and stay on track, which is what we're talking about here. Their quote 2 option for $30,000 per month. Now, I don't know why it's that $5,000 difference. I don't know what happens between those moments to get that bumped up, but they're very clearly showing and tying this to that original text message from Nathan that this is the quote 2 team. Quote 2 team is Jed Wallace and his team. We know it's Jed Wallace and his team because not only does Melissa Nathan say here Jed and his team, but Katie Case, that we just talked about, says to follow up, I've attached an invoice from Street Relations. Jed and his team are truly the best of the best. Jed responds here, thanks for connecting point, Katie. Jamie, an absolute pleasure. While the circumstances are the circumstances, this is our wheelhouse, and have it prioritized across all platform-specific specialists working for me. So Jed very clearly has a team of people. Now, they might not be employees of Straight Relations, they might be independent contractors, but he very clearly has people working for me. Jamie Heath then says, hi Jed, wonderful to meet you. Apologize for the delay. The premiere and the screening we had today has been just crazy time. This is on August 9th. Happy to have you on board. As for the invoice, adding my team so we can get this to you and taken care of ASAP. Please meet Brian, Imene, and Mitz. We've already talked about Mitz in part 1. Mitz is one of the 9 Wayfarer third parties that Lively was trying to compel but failed, and is the VP of operations. That is Mitz, oh gosh, I'm going to mess up Mitz's name now. One moment, let me bring up the notes from part 1. I don't remember. Mitz Toskovich, also known as Milika Toskovich, VP of operations. Also bringing in Imene, our head of legal. You just brought your head of legal onto the email exchange of the guy you are hiring to smear the woman who made sexual harassment complaints. What are you doing, Wayfarer? The reason I had that up before to kind of show down on here was because if you're not familiar with Imene, Imene is also in, oh, am I in Lively's complaint? Yeah, I'm in Lively's. Oh, this is Lively's amended. I need the CRD complaint. There we go. Imene is also not the first time we see this name, because Imene is not just the head of legal for Wayfarer. Imene was also legal counsel on the film when Lively's legal counsel sent over the protections for return to production, right? When they talked to her about, it's no surprise to the film's producers, the experience of shooting the film has been deeply concerning. The complaints of our client and of others have been repeatedly conveyed. So Imene isn't just on the email exchange with Jed Wallace, hiring this guy to go after Lively. Imene is deeply intimate and knows all about the sexual harassment complaints, because Imene was included on the email exchange here from Lively's lawyers asking for them and talking about, if you're unwilling to go with them, we will pursue full legal remedies against you, right? Like, we want these protections and to be a safe workplace. And then just moments before I came on here and kind of did this, I found yet another thing in his complaint. I need to go back to November because there's the emails in here From November, let's go back to where legal gets involved. March, February, December. Uh, Here it is. Um, so, Lively sends her 17-point list of protections. They argue about it with Sony, right? This is the email back from Sony saying, "Hey, we should push back. We should agree on these. Blah blah blah. We should do all this stuff." There's an email that he includes that I guess I've seen the quote, but I missed it. Do you remember in the original complaint he talked about like we although our perspective differs in many aspects. I've missed the beginning of this. Wayfarer, Sony, and production respectfully acknowledge that your client has concerns regarding safety, professionalism, and workplace culture. And it says here at the bottom, reserving rights. This is the letter back from legal, where they basically say, we respectfully acknowledge that your client has concerns regarding safety, professionalism, and workplace culture. This right here is Wayfarer's legal admitting that Lively did make sexual harassment complaints and had made complaints about workplace safety, and they were acknowledging them. The fact that then their head of legal is now on the email exchange for the guy they hire to go after her is wild to me. I do not know why the head of legal is not shutting this whole scheme down the moment they hear about it of, do you understand the legal jeopardy that you are doing here? Anyway, Brian is Brian Singer. We talked about Brian Singer, Chief Financial Officer over at Wayfarer, also on the board of No More, the domestic violence charity that they donated the profits from the film from. Sotomayor says, so that could be considered a legal document then of admitting harassment. No, it's 100% an admission, right? The point that we've had this conversation again and again of like Lively never complained about sexual harassment. They, never did. That right there is an admission. Like, and I would love lawyers, to go take this to lawyer creators. That right there, that language, Wayfarer, Sony, and production respectfully acknowledge your client has concerns regarding safety and workplace culture is an admission that Lively did make formal complaints about unsafe work environment. Them not investigating that or doing anything with that is already a huge problem. Them doing this and having legal on board is just nuts. Anyway. So they go on to say, Brian comes back and says, I forwarded a W-9 along with a name and number. And then the lawyer Imene basically says, in addition to Brian's email confirming that this falls under our agreement with the agency group and that TAG is subcontracting street relations. Jed comes back and says, hey, I'm sorry for the delayed response, wrapped up a long flight. My team has been in full throttle mode on our Wayfarer focus. We will work lockstep with TAG, but separately engaged. Attached is the W-9. Now, for my non-American audience, a W-9 is a tax document, so that when you pay another company, it identifies their tax information. So their name, their address, what their tax number is, to identify like the withholding that you're having and the withholding they're doing. So this is a document showing proof of payments between them, and all the rest of it. So that is what they're talking about with the W-9. I realize that maybe some of the non-Americans might not understand, but tax document, basically. He's forwarding on his tax information to say, hey, I want to make sure you pay the tax correctly on my stuff. And then says, looking forward to working some magic. This is crazy to me because, again, I don't know necessarily that when we talk about perjury, whether this counts, right? But it is very clear the impression that he's giving from this declaration, that it was just him, he's the only employee, he doesn't have a digital team, then who the heck is he talking about in this email of my team, my team, my team? Also remember, this is the 9th of August where he's saying that my team has been in full throttle on our Wayfarer focus. This is the time at which they hear back from him that, he has focused the narrative on Baldoni and has focused the narrative on Lively against sorry, that's the 10th. It's the next day. So yeah, he's already going for it. I think the 9th is when they say Reddit, crushing it on Reddit. I think is the 9th. Yeah, crushing it on Reddit, he says. So the day that his team hit full throttle, crushing it on Reddit. But again, he's only watching. He's not doing anything active. Crazy to me. I think that's everything here that we're going to talk about on this piece right now. We're going to come back to this in a little bit. Let me just check, and then we'll check what you guys have got to say. Oh no, there is one other piece that I missed. Oh, so that was the bit that I was calling out here, where they're talking about, can we confirm? So the lawyer, the head of legal, is confirming TAG is subcontracting, and Jed Wallace confirms and says, no, we'll work with TAG, but we'll engage separately. We will be engaged directly with Wayfarer, which is why he's sending over the W-9. That's why I wanted to bring this up. So the W-9 is so that Wayfarer have the tax information so that they can engage and pay directly for Jed. I bring all of this up because you may remember a little long time ago. Oh, I guess, did I not put the folder? Yes, I did. I did put it in here. So this document is Wayfarer's answers to Lively's complaint. So if you remember, we've gone through this. You have to go through line by line, admit, deny, admit, deny, all the way through here. Now, in her complaint, Lively alleged that TAG retained Jed Wallace. And of the first set of answers, TAG did say, yes, we retained him. And then in the second set of answers, everybody all said, wrong one. We'll get there. We'll get there. I'll have it together in a minute. There we go. So everybody responded in their answers that, oh, no, originally TAG erroneously stated that it had retained Wallace. But then everybody all said, defendant lacks knowledge to form a belief as to the truth of the allegations. It wasn't just, oh, never mind, we won't bring it up. It wasn't just Wayfarer, it was everybody on the case. They all said the same thing, that TAG erroneously said that they had retained Wallace, but we don't know the truth. We have no idea. Nobody knows. Nobody knows who retained him. Yeah, you do. Wayfarer knows because they've got the W-9 that they paid for Wallace with. We know who retained Jed Wallace. It was Wayfarer, and these emails prove it. So this is already not great for Wayfarer because I don't know if lacks belief to the truth of the allegations can be bent sufficiently to say we don't know whether TAG retained him as well or whatever. But it is very clear that answer 222 should have been, we retained Wallace. I don't know what the consequences of lying in your answers to your complaint are. But I'd be interested to know and see if Lively's team go after them for that. Yeah. Oh, that Jed Wallace. It's funny, isn't it? You guys remember this because I think I went through this and we all laughed and joked about how nobody in any of their answers knew who Jed Wallace. Jed who? Jed Wallace? And we talked about like Jed Wallace was the friends we made along the way. Like we're all Jed Wallace. Who's Jed Wallace? This mystery man. We have proof now that Wayfarer engaged Jed Wallace, and yet in their answers to Lively's complaint, Wayfarer did not correct that information and claimed that they do not have sufficient information to know who retained Jed Wallace, which we know not true. All right, so that's problematic. So like I say, I don't know if Jed's answers here about having a team are enough to bend a lot of what he'd said in his declaration, but it very clearly shows that not the whole truth here, if nothing else. It doesn't show that he necessarily said something that was wrong, but it is very clearly not the whole truth. Jed very clearly did have a team and was engaging with people. Now, what he was getting them to do, we still don't have confirmation. This doesn't prove that there was a smear campaign or that he was directing this stuff, but it does show that Wayfarer were engaged and that Wayfarer were paying him the $30,000 a month for 3 months, $90,000. Now, I have worked in social media and worked for media companies. I will tell you that monitoring a single company across social media is not $30,000 of work. It is not. So either they were dramatically overpaying, or he was doing something else. I do find it very inconceivable that Wayfarer were paying $25,000 a month to Jonesworks for PR during the time of which they launched their biggest project, their biggest movie to date, and that Jonesworks was apparently not watching social media sentiment and looking for articles going on about them. They were also paying $15,000 a month to Tag for crisis PR, who were specifically brought on to monitor and watch social media and media content and sentiment about Justin Baldoni so that they could help shape any negative information that's coming out of him. And apparently they were also not doing this work of monitoring social media and performing sentiment analysis. They instead had to pay an extra $30,000 to a third company who was the only people who at the time of them launching their biggest project thought, hey, we should maybe check out what the sentiment about Justin Baldoni and Wayfarer is as they launch their big movie. I don't find that a convincing argument, and I think you have to be very gullible to believe that they were already paying $40,000 a month for PR, and then had to pay an additional $30,000 to have a single person just watching Reddit and Instagram on their behalf. No, absolutely no. I don't buy that for a second. I think everybody who sees that he was paid $90,000 to sit on social media and look for information about Baldoni says, I want that job. There's a reason, because we know that that's not the job. We know you're not getting paid $90,000 for 3 months for sitting on social media and watching sentiment. It's just not going to happen. I don't care how good he is. Paying all this money for people who claim they didn't do the jobs too. Yes. All right, so that was Jed Wallace. We're going to move on to Matthew Mitchell. So Matthew Mitchell is a former Jonesworks employee, not just an employee, but also a VP, vice president over at Jonesworks. He was helping Jennifer Abel to run the Wayfarer account. We know this because when Baldoni gave us his amended complaint, or rather, this is the 179-page complaint. It was also in the New York complaint. It's just unreadable in the New York one. The 179-page complaint, at least you can make out the names here. But Matthew Mitchell was involved. You can see in this group text here with Katie Case over from Tag, Jennifer Abel, and Matthew Mitchell, where they're talking about largely seeing that shift on social, largely due to Jed and his team's efforts. Matthew Mitchell happy to jump on, talking about having a Zoom without Justin. Happy to Zoom. He was on that. He's also on the email that between Stephanie and Jamie were in August 21st, when there's the difficulty between Jonesworks and they've shut her out. Jones calls out that on August 9th, you indicated that you only wanted Jennifer Abel and Matthew Mitchell and team to communicate on behalf of Justin and Wayfarer. So Matthew was, like I say, the vice president over at Jonesworks who was working on the complaint. Well, Lively has filed a motion to serve a subpoena on Matthew Mitchell because, unfortunately, after 8 failed attempts at service, Lively's counsel attempted to call him on a phone number and got no response. So they tried a bunch of times, showing up at his apartment, couldn't get him. So she has asked for, okay, we need to give him, serve him, but do so in an alternative manner. They have asked if they could serve him by telephone and LinkedIn, because they noticed that his LinkedIn was active because he had changed and updated his LinkedIn profile since he left Jonesworks in February. He left Jonesworks in February. And so because he'd updated his LinkedIn to show that, they're saying, hey, he's active on there. Can we serve him? Now, ironically, the same day that Lively brought this to court, Matthew did indeed update his LinkedIn after like a 5-month hiatus and commented on a friend's post about them getting a new job. And you can see it wasn't just the automated congrats, like he'd actually written out a rest of it too. And it was posted like the day before that Lively served that to the court. Now, he couldn't have known that that was incoming, but I thought that was kind of amusing that they're like, oh, that happened. So she'd asked for that. And surprisingly, the judge said, yeah, go for it. He said, you can totally do that, but you also have to make sure that he gets it. So we'll let you do that, but on the grounds that you also attach the document to his last known residence, mail the documents to his last known residence, send a copy of the document to Mitchell via LinkedIn, and attempt to contact him on the telephone number and go get him served. So, interesting. Fun times. Served by LinkedIn. Okay, so now we're getting to the tag employees. This is the last piece that we're going to get to tonight. So Lively also served yet another motion to compel, right? There was one I missed in the earlier part one of all of those motion to compels. There's one still outstanding, and that is the motion to compel Katie Case and Brianna Kozlow, who are employees of the agency group. Katie Case is a former employee of the agency group. Brianna Kozlow still works there. And they have been working with them on trying to get their documents from them since March. Marcy Jinx says, everyone's dodging subpoenas. Interesting. Yeah, and again, like to kind of bring back up from what we talked about at part one, right? So part one, we were talking about the people who were dodging the subpoenas were the Wayfair executives, most of whom were involved and knew about what was going on. The executive assistants who were present on set with Mr. Heath and Mr. Baldoni, who would have intimate knowledge of the events on set, they are ducking producing any information. And now we have employees of TAG who were engaged on the crisis PR with Wayfair, who are also ducking this. There doesn't seem to be anybody on the Wayfarer or TAG side who wants to comply with discovery, who wants to basically prove Baldoni's innocence, right? They don't want to turn over all of the documents showing that Baldoni's telling you the truth. They all seem to want to be very, very tight-lipped. So she basically says, look, they need to be compelled because we've been working with them, and you know we've been working since March to negotiate a way to get their materials, trying to reduce them, modifying their requests so they wouldn't be such a burden. They raised new objections for the first time, and so now we've realized, look, we can't do this, right? They're not going to comply, so now the court should step in and intervene. So who are they? Well, we talked about Katie Case because Katie was originally mentioned, right, on the Jed Wallace meme that we just talked about, which I just gave away, right? It was this text message. So far, extremely limited pickup on Daily Mail. We'll continue to keep sending out pieces. We've started to see a shift on social due largely to Jed and his team's efforts to shift the narrative towards shining a spotlight on Blake and Ryan. Again, we'll continue to send links and screenshots, but wanted to send an update in the meantime. Now, the name's redacted here to Jennifer Label, but we knew that it was Katie Case because when Baldoni filed his New York complaint and responded and was desperate to show us all of the text messages that Lively had excluded that completely changed the context, where they're talking about having a Zoom that doesn't include Justin and they all say they can join, and Matthew Mitchell says no one needs to see this today because he's going to turn off his camera, so you know he doesn't have to get made up to be on Zoom. Completely obviously changing the entire narrative of Jed Wallace and his team, shifting the efforts to shift the narrative towards shining a spotlight on Blake and Ryan. But anyway, they included the names on here, right? Lively had redacted them. Baldoni was only too happy to throw everybody under the bus, including Katie Case here, and as we just talked about, Matthew Mitchell. Katie Case was also included on the original logs, the subpoenas for T-Mobile, like we talked about in part one, where Jerice was included on there. Katie Case and Brianna Kozlow were included on the original phone subpoenas from back in February. So they've always been people of great interest to Lively, and Matthew Mitchell's also included on here. I talked about she was the person who sent that text message. And so Lively also includes the whole text message, the whole email exchange that has been going on since forever. You can see, look, all of these freaking footers again and again, back and forth. So you can see how many emails deep we are in this nonsense of the email exchange. So it shows back in March, Kristen Bender talking about, we understand from notices of appearance that you represent Catherine Case and Brianna Kozlow. Please, will you accept service of the attached subpoenas, right? So they served the subpoenas to them on March the 3rd. Exactly the email we're expecting. Happy to work with you on this matter. Oh, we're all just friends together. Let's go for it. Great. Thank you, Max. Likewise. Please find attached our objections, right? They're going to start narrowing down what they've got a problem with. And they talk about, well, you know, recall you flamed the conversation after meeting conferrers. Why us? Why now? I've listed proposed several modifications to address your concerns regarding the timing of party discovery in an attempt to further lessen the burden on Ms. Case and Ms. Kozlow. So they've added a limitation of documents and communications with Baldoni, Heath, Sarowitz, or Abel need not be produced. So we've gone through a bunch of these motions to compels where they've said, hey, you can get these materials from the parties instead of getting them from us. You should get them from the parties first, all right? And that appears to be the objection here from Kozlow and Case. So Lively's team are saying, cool, don't worry about it. Don't worry about producing just your direct communications with Baldoni, Heath, Sarowitz, or Abel, because we'll get them from Wayfarer. They've changed with or concerning to just with, to just concerning, and then added the limitation of with Sony, Jones Works, WOG, Tag, Wallace Street Relations, you know, to another RFP to kind of limit it as well. Solometa says, this email chain frustrating when I read it. Definite kudos to lawyers. Oh, it's going to get more frustrating in a minute. It's going to get real frustrating. So they say, oh, we're checking the status in our proposed outline. We've considered your proposal for narrowing and think it makes sense to confer. So they don't want to give an answer. They want to talk again. So now they do a bunch of emails back and forth trying to figure out when they can talk. And so again, comes more limitations. Revised our definition for action with consolidated action. And it means and collectively refers to the following cases: Lively versus Wayfarer and Wayfarer versus Lively. Revise all documents and communications concerning Miss Lively, Miss Reynolds, the Lively companies, and the Reynolds families, excluding documents or communications with Baldoni, Heath, Sarowitz, Abel, or Jones. And they've done the same here to add on for the rest of them, excluding documents Baldoni, Heath, Sarowitz, Abel, or Jones, because, you know, she could get those materials from Jones instead, because Jones at this point was still a party to the lawsuit. And then they're going to say revise all documentation concerning the film or marketing plan with Sony, Jones, Works, Street Relations, Tag, Rennie Media, social media, blah, 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 blah. Again, more limitations adding in Jones to basically say anything that we can get from somebody else, we will go. I think that was it. To further reduce any burden to Miss Case or Miss Kozlow, if Miss Case or Kozlow are currently employed by Tag, we are amenable to an agreement whereby Tag conducts a reasonable search for responsive non-privileged documents and communications of the individual's personal cell phone devices in connection with party discovery. We expect the Wayfarer parties should be amenable to this compromise if they've been attending the meeting confers, apparently in connection with interests associated with subpoenas, and are obligated to conduct such under a search in New York law. So they're saying, look, if you're still a current employee of Tag, we'll put the burden on Tag to produce all the rest of the stuff, and you just have to produce the stuff from your personal phone, like the personal information that you have related to the request that we've given you. They come back and they still say, oh, we need another meet and confer to narrow it down further. There's a bunch more emails as they try to figure out a time to be able to do this meet and confer. And then come back and say, Lively's team, or Manat, basically come back and say, okay, so now you've proposed a self-search where you would do a custodial interview of each client, and then an attorney would collect the information. The custodial interview would determine, among other things, what devices they would collect. We understood that under your proposal, messages would be produced as screenshots. Yeah, they're not going to send the messages that are on the phone. They're just going to snap a shot, send those over. Lively's team is basically say, yeah, we're not comfortable in that. We explained that because Case and Kozlow were Tag employees directly involved in the digital campaign, their documents and metadata are highly relevant. You confirmed in production method would likely not inherently include any metadata, but agreed, subject to your client sign-off, that you provide information as to date, time, identities of parties in conjunction with the production. We asked what your basis for proposing a self-search rather than a forensic collection of your devices, and they basically said it's unduly burdensome, and they didn't want to have their phones searched Basically, we learned from Jennifer Abel that that's probably not a good idea. Um, so, uh, so I think that's what they don't actually respond here to the part of it. So they do say, um, additionally, we asked for you to confirm whether you were still employees of Tag and whether you discussed with tax counsel if they would do the imaging of your phones and reduce your client's burden, but they hadn't responded. So basically, they say that coming back here, um, I can't remember. They want to do this self search and provide screenshots. Lively's team basically come back and say, look, we will pay for it. Lively, it says, I think somewhere in here, we put follows the followings. Lively agrees to cover the cost of the vendor. We will image your phones for you. Not only that, but as we're going to do it, they also talk about the collection itself will be available for comprehensive format. Go to a review database for culling. Ms. Case and Coslow's devices will be not accessible to anyone, including the vendor, absent further processing, and at conclusion, such information will be appropriately destroyed. So we're going to protect your privacy of all the stuff that you don't want to send us. We're going to image them, you go through review, and then send us what's relevant. They come back and then start arguing about the date. Again, trying to arrange another time. It's just lots of this and infuriating. And then try to say instead that they don't agree to it and that they still have other pieces that they want to do. Where are we? Since our call, we've confirmed that your clients do not object. They come back and say, no, we do object. We only want to provide from, here's our usual time date, July 1st to December 21st. And that they don't want to include group texts either for some reason. So this is why Lively's going for the motion. So the Tag employees respond, and they basically say everything that is in that email exchange. They then try to argue that because Lively reduced the amount or extent of the subpoenas, that therefore they were accepting that they were too much. Agreements had been reached to limit the subpoenas and shift electronic costs, with the only outstanding issues being raised the time period and whether the group text should be searched. And that, if you do agree on compelling us, that it should limit to the subpoenas and provide a collect only to what we were asked for. Here it is. There it is. Lively should also be bound by our council's agreements concerning the subpoenas. Were compliance to be ordered, any compliance order should include the limitations and mitigations already offered and agreed, right? I can't remember where it says that they were already broad and agreed to them. I'm trying to find that piece. I don't see it. I don't see where the other piece had already said that they had agreed to it, so therefore that it was. But they do say that, look, Lively subpoenas are neither narrowly tailored or proportionate, which was interesting to me because here they say, if you do grant it, grant the modified one. But that seems to be an acceptance that you agree that the modified one isn't an undue burden and not narrowed enough. You're saying you'll agree to the narrowed one, just the two pieces that you want, the date time. Lively has come back. Oh, this is the bit that frustrated me. They attached 9 exhibits. They include the email, right? They start here at this one on April 3rd. They include these other emails from what we just talked about, where Lively's lawyers served them, and then include this email here, hi Dan, Max, Megan, on April 3rd. They attached 9 exhibits. Each exhibit is the same email thread that we just saw on Lively's. They just increasingly attach more emails to it. So you can see here, notice of serving you on March 3rd. Where are we? Here, Dan, Max, Megan. This is the April 3rd email that is the top of this one, but it is now on page 13 here. They add a bunch more emails in here. This is exhibit 4. By the time we get to Exhibit 9, right, we're at 26 pages, and here's the notice of serving, and then here's the rest of the email chain. Where's the hi Dan, Megan, Max? Yeah, that's on page 20. Was on the first page of the first exhibit, and then they include the rest of. It's the same emails that's in Lively's. But they attached it as 9 separate exhibits, and this drove me nuts. I was like, this is a waste of time. Why did you do this? So appreciate it, Tag Council. Thank you for those minutes of my life that I will never get back. Anyway, oh, that was the other thing they argued. I forgot about that. That was the hilarious part that they argued. That they are being subpoenaed, but they tried to argue here that they are, employees of the agency group, but neither features in the operative complaint, and nor have their communications with parties or principals appeared in party productions. The reason our clients were but party employees. They're trying to say neither of them has their communications in any of the complaints. What are you talking about? Like we know that your text messages right here are in the complaints. This is Katie Case's text message. How are you going to say that you're not included? They also say that, none of our communications with parties have appeared in party productions. Well, that's also not true, because we got the email right here from Katie Case from Jed Wallace. Jed Wallace's productions produced Katie's emails. So yes, she is very relevant and involved, because her text messages and information is showing up in the text messages and emails from the other parties. What are you talking about that they have not been produced and appeared in party productions? Absolute nonsense. But it's another example of them just trying to lie their way through this. And the only reason they get to make this lie, right, is because Blake Lively redacted her name from this text message. So this is the only way they get to turn around and say, well, our communications were not featured in the complaint. Well, yeah, they were, but you can only say that because they were redacted. She was protecting your privacy. Thankfully, Baldoni didn't bother about doing that and just named you right off the bat. You might want to look into that. But, it's crazy. It's crazy that these lawyers will do this. So anyway, Lively has come back to argue their suggestion that they were but party employees is an attempt to minimize their involvement, but cannot be squared with reality. As previously stated, and contrary to the opposition, these individuals' communications feature prominently in the operative complaint, with non-party names redacted for privacy, and evidence their participation in a retaliatory digital effort. And we'll go over those in a second. But she argues to go first. We engaged in good faith with respect to the subpoenas. There's no reasonable basis to assert otherwise. Their good faith, it cannot be contended that Case and Kozlow lacked notice, right? That the motion to compel was coming because they said so in the email that we need to move ahead, and if you don't agree, then, we're going to compel you. Where's the bit that I was looking for? Trade-off. Okay, this is all the way down here. So they also talk about why they haven't shown how they're unduly burdensome. We've removed a lot of the burden, and they haven't done it. The subpoena request should not be limited to the retroactive agreement that they did, because originally they did this as, where are we? It says, as memorialized on May 6th, Counsel for Lively stated, on our meet and confer yesterday, you agreed that Kozlow and Case would produce documents responsive to Lively's request, so long as we agree to your proposal and collection methods. Kozlow said, we have not yet reached agreement on the scope of our services, saying that there was multiple areas of disagreement and only referencing the potential of future agreement. So they say, look, we proposed those modifications to the subpoena request, right, saying that we only wanted from Katie Case and Brianna Kozlow because we wanted to get them quickly, right, to facilitate timely third-party productions that could have been used in connection with unfolding discovery, while allowing time for Lively to evaluate productions from the Wayfarer parties and then revisit certain requests with Case and Kozlow. So you just produce me what you have on your personal devices. We'll let Tag and Wayfarer produce the other conversations with you, and then if there's anything missing, we can come back. That attempted trade-off, scope for timeliness, was ineffective, as evidenced by the months that have passed and the necessity of the instant motion. The fact that the Wayfarer parties have not made significant productions or induced any production reflecting Case or Coslow. Wayfarer haven't produced any of those messages that involve you. So we can't get them from Wayfarer. So now we want everything. We don't want to just limit it to give me everything you've got apart from your communications with Wayfarer, because Wayfarer didn't provide the other side of it. Wayfarer didn't provide the communications with you. So this whole like reducing the burden by getting them from a party in the complaint doesn't work, because the party in the complaint is refusing to produce them. At present, Case and Coslow's compliance with the subpoenas will take place at earliest essentially in tandem with the majority of the Wayfarer parties' document production. Courts do not hold the parties' good faith attempts to confer against them, and given this, the subpoena requests as initially framed and served are the appropriate subject of Ms. Lively's motion to compel. We need the whole thing. They talk about down here, in particular, Case and Coslow's proposal that they be exempted from producing the communications with the Wayfarer parties, whether in individual or group text, is now unworkable. Given the expedited discovery timeline and the difficulty in securing any agreement from Case and Coslow with regard to the subpoenas, there was simply no time to review the Wayfarer party's voluminous production for gaps in communications with Case and Coslow, serve new subpoenas, and then obtain and review documents prior to the closing of discovery. Revisiting the scope of their productions after the close of party discovery would be so delayed as to be virtually useless. Basically saying there isn't enough time now for us to only get pieces from Case and Coslow, the rest from Wayfarer, and then figure out the gaps. We need everything from them, and we need it from them now. Well, the judge came back, and his verdict is we're getting another hearing. On Tuesday at 2 p.m. Eastern, we're getting another hearing. There's a dial-in number with a PIN number. I think it was said before at the last hearing, so I will say it at this one. If you plan on being a participant and you want to dial in, know that that information, I believe, is logged and recorded. So I don't know who it's provided to or who has that information. I don't know if both sides get to see a list of phone numbers or whatever that are providing in, but just know that your phone number may not be private if you dial into this hearing to listen in. Also know, do not do what people did the first time with the first hearing. You cannot record the hearing. You certainly cannot live stream the hearing and put your own sound effects over the top, mocking all of the stuff that's going on. Or rather, you can, and apparently there's no consequence for it, but you should not. So I will let you know, don't do that. But if you want to dial in, feel free. There will likely be, I guess, a transcript afterwards like there was with the first one. I don't know if it'll be produced as part of other evidence that gets logged, which is how the first one was. There's not necessarily a transcript provided, but I'm fairly sure that most of the creators on this are going to be talking about it and going to be either live typing or whatever it. I will not be one of those, unfortunately. It is not at a convenient time for me, so I do not believe that I will, but I don't know. I might be. We'll see. We'll see. There might be some threads going on, but we'll see what goes on. So yes, so if you wanted interested to going on to hear what is going to get decided, Judge Lyman has said he needs to immediately talk to both sides. Now this will only be between Lively's counsel and Case and Coslow's. Wayfarer will not be involved, so just know that as well. And as part of her response here, Lively also included the various emails and stuff that are included that Katie Case and Brianna Coslow are included on. So let's go through the list here. So I've talked about this a couple of times. This is the email that we just talked about, like kicked off the whole email chain here with Jed Wallace and Katie Case, right? Talking about the payment and stuff, where Abel is responding to Katie asking about the pricing and saying, hey, does this cover your initial fee? Does this cover Tag's initial fee? Or is it in addition to the 15K that we paid for Tag? In short, is the total fee 30K or is there more? And it was more, right? The 30K was just Jed Wallace's fee and Tag's fee was 15K. So they paid $45,000 a month for Tag and Wallace together. But in Lively's complaint, complaint, sorry, in Lively's response, right, to this motion, she details here who was involved in all of the text messages. So I'm going to read it out as we look at it, right? So this text message here about the tag pricing is from Abel, and it is to Katie Case, Brianna Coslow, Jamie Heath, and Melissa Nathan. So the other two names are off here. There is also this story where Jennifer Abel is sending to a group of people flagging a video, a TikTok video. Is it TikTok? Flag to tag that this girl is claiming that Baldoni invited her up to our hotel room years ago. So it's something on social media. She says, I don't want to share the video, but I did a screen record, and this is her account. So guys, can you look at it? Part of me wants to, I think it was contact his former assistant to say this never happened. Ridiculous. And then they respond and say, let us chat to Jed on this as well. So they're sending Jed after whoever posted this to her account, talking about Justin invited her to his hotel room years ago. This is a text message from Jennifer Abel to Matthew Mitchell, that we talked about, the guy who's being subpoenaed via LinkedIn, Melissa Nathan, Katie Case, and Brianna Coslow. The other text message she talks about and refers to is this one. We talked about this. This is one that doesn't get much talking about, and it's the only text messages in all of their answers that the Wayfarer parties denied. In all of the other text messages, they say that this text message happened, it is an accurate text message, but the context is wrong. This is the only one in which they deny completely all allegations. This is a text message from Katie Case to Matthew Mitchell, Melissa Nathan, and Jennifer Abel, asking, hey guys, regarding the TMZ thing, regarding the HR complaints, our understanding is two were from Blake and blah, re the sexy comment is the additional one from blah, reading the thing with Jamie in her apartment in New York. Just want to clarify, which is widely suspected to be, oh my gosh, I've just drawn a blank, Jenny Slate, based on the Hollywood Reporter leak, right, which we think comes from Baldoni's camp. So they were talking about there being 3 HR complaints, and the people who were talking about it were Katie Case, Matthew Mitchell, Melissa Nathan, and Jennifer Abel. So yes, of course, it's important that we talk to or get the materials from Katie Case and Matthew Mitchell, because they apparently knew about HR complaints. So it'd be interesting to see, were there any other conversations about HR complaints, and what was the rest of this email thread and chain. So yeah, so it's been an interesting week with all of the motions to compel, but like I say, between this email exchange with Wallace, where we see more details and know that he was team 2 for $30,000 a month, that Katie Case was involved, it'll be interesting to see what happens with this hearing, because I think Lively is correct that I do think this needs to be broadened now with Wayfarer not producing, as we talked about in part 1. They're not producing any of their material really at all. It's going to make it very difficult for them to defend themselves, but it also makes it very difficult for Lively to continue with her case and get the materials that she needs. But that, as we talked about in part 1, might then lean towards some sort of judgment, because if there cannot be evidence, then the judge can decide that the reason for that is because Wayfarer don't want to incriminate themselves and make a judgment based off that. So we will see. We will see. But yeah, just to kind of give you, again, an idea, nearly 3,000 documents from Blake Lively alone, 75 each from the Wayfarer parties. So it's understandable why it is so important that, from these third parties, like Catherine Case and Brianna Coslow, as burdensome as it may be to image their devices and get all of their messages, it does not look like Wayfarer producing them. And so it is the only way to get the conversations between them and Wayfarer, which are highly relevant because we talked about they're directly at the heart of talking with Nathan and Jed Wallace on the activity of the smear campaign, and then also Katie Case directly reporting that we've started to see a shift on social due largely to Jed and his team's efforts to shift the narrative towards shining a spotlight on Blake and Ryan. That doesn't sound like observation and monitoring. That sounds like something proactive. Cool. All right. I will do a quick review of chat and then we will be done. Thank you so much for sticking out and making it towards the end of part 2. We got through a lot this week. Mazajig saying that was so annoying. Look at how much we attached. Yeah, 9 different attachments of the same email, and it's the same email thread that Lively attached. And then you could have just attached number 9. Like there's no email in number 9 that, or sorry, in number 1 that isn't in number 9. And then you just got all of this fodder nonsense, this back and forth, this back and forth. Like the 8 million emails trying to line up schedules. Oh, what about this? Yes, that sounds great. Oh no, something's come up. Oh, something's come up, move. Like that would frustrate me because I'm sure it's in good faith. I'm sure it's just lawyers being lawyers and being busy, but like it feels like you're trying to dodge me. Like I would be so frustrated by it. Oh, it's a lot. Solomon says, do you think these 9 attachments in the same email is an attempt to boost the number of documents they provided? I honestly just think it was a mechanism just for getting my blood pressure up in particular, just me. I really do feel they sat there and thought, I can't wait to see Expatriarch on live stream fight for his life through these 9 exhibits. And yeah, I will say that Prior Cashman here, the law firm, your name is burned in my head now for wasting my time like that. I will know you forever. Marcy Tink says Judge Lyman must be upset. I don't know if he's upset. I don't know what. Because it's interesting to me, having talked to Part 1 and his responses on the motion to compel there, where he seems very lackadaisical and not really concerned with the speed of production and discovery, to get an immediate ask for a hearing on this almost immediately after Lively posted this seems off. I don't know why that would be. So I will definitely be listening in. I will be interested to hear what gets said in that. I will probably just write notes as I'm doing it and thread about it afterwards so that I can focus and concentrate. But we'll see. Solomon says, I'm going to be so disappointed if we can't uncover what took place. They think this could be a huge can of worms, but not just in general, but in the online smear campaigns in general. Yes, and I talked about that as well, right? Like that is, I think, the disappointing thing that we should all brace ourselves for, right? That the core of this case is sexual harassment and retaliation, not the smear campaign. That they did the smear campaign is enough for her to prove her case and win, right? I would love for it to all be exposed. I would love for them to really dig deep and find out Liner, Friedman, Tattleman, and Cooley's involvement in it. I think, given as what we've talked about before, there's a history here. This is a pattern of behavior that consistently happens. I would love nothing more than for this to be the case that exposes all of that and blows it all open, and shows the work that Jed Wallace, or allegedly Jed Wallace, and those people have done, the way that social media has been weaponized against certain celebrities and women in order to tear them down. Like, yes, of course, I'm excited. I would love all of that. But I think it's worth reminding that that is not what the core of this is about. The core of what this is about is an unsafe working environment, somebody standing up to provide protections, not just for themselves, but for everybody on set, and then being retaliated at and having her reputation destroyed in response to that in order to invalidate her claims, so that they could protect the ego and reputation of the abusive men she called out. So that's the goal. That is the main prize, right? The other stuff would be interesting, and like you say, for the tea, I would love to know more about it. We hopefully will get answers. We may never know. The bits that we have seen have been enough to show just how easy it is. And how I think the devastating part for me is how many people are willing to be okay with it and be involved in it and drive it and feel it is justified. I go back to, Jennifer Abel's message where she talks about, they talk about, oh, it just shows you how easy it is to do, go after a woman and get people to go after a woman and drag her down, and it's sad. And she says, yeah, but don't be a C word. Like, she really did this to herself with the unfollow thing and refusing to take pictures. It is insane to me when we look at everything that has gone on through this case, that you would think that it is justified, that you don't want to take pictures with like a work colleague that you think is unsafe, and you unfollow them in social media, and everything that has followed this is entirely justified because of that. That is crazy to me. Anyway, they've desperately tried to make this all about Blake and Taylor, so everyone forgets it's about sexual harassment and retaliation. Yes, absolutely. And that's where we need to put the focus back on. And next week, when I come back, we'll be doing docket updates. And then I'm hoping to also have a second stream as well, which will be where we talk specifically about sexual harassment, retaliation, the amicus briefs that I have never yet talked about, because I really do think it's important. A lot of people have talked about the sexual harassment aspect, and that she didn't say sexual harassment and didn't bring it up. And I think it's important to go back to employment law and talk about what that looks like in a work environment, what counts as sexual harassment, and impact that with regards to the case, and then also do that in light of the amicus briefs and how DAVO and retaliation is often used against those complaints. So yes, we got a lot to go through for the next week. Hope you have a great rest of your evening. I hope you have a great week coming up. Thank you so much for joining with me. Again, as always, if you like what we're doing here, like, comment, share it with other people, help spread the knowledge around. If you have questions, if you have things that you want to know more about, if there's still things about this that you just don't quite understand, ask in the comments. Either myself or the other people will absolutely help you out. And with that, I will go through and just quickly say goodnight, and thank you so much to Marcy Jinx, to My Lady, to Subtle Murder, Obi-Mom, Kenobi, Caspian. As I quickly scroll up, of course, Gina Richardson, who was here earlier. Junk Farm, as always, thank you so much for being here. And I'm trying to see, who else did I miss? Gotta be somebody up here. Oh, I guess TA had come in earlier and said that the Taylor Swift extortion content already covered. Yes, that was part 1, but thank you for popping in. I think that was everybody. If I missed you, I am so sorry. But otherwise, guys, I will see you next week. Thanks so much for hanging out. We will do this all again. Until then, yeah, have fun. Or try to, as best you can with everything that is going on. I will see you then.